We're ready for the HCI versus Bush case.
Good morning.
Morning.
May it please the court, David Baruch on behalf of Homeowners Choice, and I'd like to reserve 5 minutes for rebuttal, please. This appeal involves a homeowner's policy and a dispute over the cause of damage to a roof. HCI contends that the roof was damaged by 15 years of wear and tear and faulty construction and maintenance. Mr. Bush contends that the damage was caused by a hailstorm in July of 2012, and the jury found in Mr. Bush's favor. This appeal is premised on 3 errors. First, that the trial court erred in directing a verdict on HCI's affirmative defenses based on our coverage exclusions. Second, that the jury was improperly instructed on legal causation. And third, that the trial court made several errors.
The legal causation's been resolved, has it not?
Only in part, Your Honor. The Florida Supreme Court SIVO decision certainly adds some clarity to the issue before the court.
Well, I would think, yeah.
It's not our key issue, Your Honor, but there are still some aspects of the legal causation instructions that give us pause. Our key issue, our foremost issue, is the directed verdict on HCI's affirmative defenses, which were based on our coverage exclusions. This is an all-risk policy. It provides coverage for direct loss to the dwelling, except that coverage is not extended for loss caused by wear and tear and deterioration, or from faulty workmanship, such as faulty construction and faulty maintenance. Prior to the trial, HCI certainly raised these affirmative defenses as a part of its response to the complaint, and prior to trial, they were included in the jury instructions and in the verdict form.
Do you agree there's a difference between an affirmative defense and a defense?
Certainly, Your Honor.
Okay, what's the difference?
Well, I think the difference certainly touches on the burden of proof. Who has the burden of proof? And in a case like this with an all-risk policy, there's a very established burden shifting, and it's very clear that coverage exclusions are affirmative defenses that we have the burden of proving. So in other words, they have the burden of proving direct loss during the coverage period.
Isn't an affirmative defense also usually kind of an acknowledgement that even if the complaint, the allegations are true, you still don't recover because these additional things have taken place?
That's correct, Your Honor. And in the context of an all-risk policy, the burden shifting is they have to prove some direct loss during the coverage period.
Right. But you all were denying that the roof was damaged by hail. Right?
Correct, Your Honor.
Okay. And your defense was, no, the reason the roof's damaged is because wear and tear, lack of maintenance, walking on the roof, etc. And, you know, I'm thinking like in a car accident case, okay? If a plaintiff says, I was injured because the other driver drove in a negligent fashion, and the defense is, no, we didn't drive in a negligent fashion, that doesn't have to be raised as an affirmative defense, correct?
That's correct.
I'm struggling with the idea of why these are affirmative defenses as opposed to just defenses saying, no, it wasn't. The reason the roof's damaged isn't because of hail, it's because of these other things.
Correct, Your Honor. And I think it's specific to this context of an all-risk policy. And in our briefs, we cite case after case after case that explains the burden shifting that applies in this context and clearly identifies coverage exclusions as affirmative defenses. It's something that we have to plead. It is something that we have to take the burden on, and it's a heavy burden after SIBO. So the jury instructions, and the parties agreed going into the trial that these were affirmative defenses. If you look at the plaintiff's proposed jury instructions and the plaintiff's proposed verdict form prior to trial, these coverage exclusions were set off as affirmative defenses that we have to prove by the greater weight of the evidence. And that changed with the directed verdict. The evidence at trial showed that this was a roof that had construction issues way back to 1997 when it was first installed, that it was a roof that has a 20-year life, and it was 15 years into that 20-year life. And as Your Honor observed, was frequently trodden upon and was full sun exposed.
But your client agreed to a replacement value policy. In other words, they're worried that it's a 15-year roof. They didn't have to offer a replacement value policy, correct?
It is a replacement policy,
Right.
yes, Your Honor.
I mean, your client was not compelled to grant a replacement value policy. I mean, your
This is,
client could have said, we have the right, to reduce by, the life expectancy of the roof and,
Correct, Your
prorate
Honor.
that. But
We-
they
we-
didn't choose to do that.
that is correct. This is
All right,
not.
But I
a-
assume if they had, the premium would have been different. I mean, replacement value is, kind of more of a benefit for the insured, so I assume they pay a greater premium for it. So, the claim that it's a 15-year, roof and they shouldn't have to pay the full replacement value, I mean, that's something that the parties contracted to. I mean, they paid a higher premium, you offer a replacement value policy. So why is that a key factor in this case, how old the roof is?
Two separate issues, Your Honor. There's liability, there's the existence or not of coverage, and then there's the amount of damages. We would have charged a lower premium for an actual cash value policy, a market value policy. So we have to pay, once coverage is established, we have to repay the replacement cost for either the replacement or the repairs to the roof. But there's the whole separate issue of coverage. Coverage has to be established first. And that's where in an all-risk policy, and again in case after case, it explains that these coverage exclusions are affirmative defenses. That is what the parties agreed to going into this trial. And despite all of the evidence that the sole cause of damage to this roof was 15 years of wear and tear, sun exposure, walking on the roof, construction issues
There's
that...
conflicting evidence on that. I mean,
There is, Your Honor.
Y'all's evidence was, the sole evidence was the wear and tear, et cetera. And the plaintiff's evidence was no, the primary cause was the hail damage.
That is exactly our point, Your Honor.
That was for the jury to make that decision, and am I correct that you all were not precluded in any way from arguing that the damage was caused by wear and tear, lack of maintenance, walking on the roof, et cetera?
We were, Your Honor. And
Were
that is...
precluded.
We were precluded, Your Honor, in this sense. That you're exactly right, that was a conflict in the evidence. And the law on directed verdicts is you cannot enter a directed verdict if there is a conflict in the evidence. That issue has to be submitted to the jury. In this case, the issue was not fairly submitted to the jury because our affirmative defenses, our coverage exclusions, after the close of our case, were eliminated from the jury instructions. They were eliminated from the verdict form. We have a heavy burden with SIBO and the clarification in SIBO. We have to prove by the greater weight of the evidence that the sole proximate cause of the damage to this roof, and that's our position. Our position.
Were the affirmative defenses listed as issues to be tried in the pretrial step or pretrial statement?
They were, Your Honor, not only in the proposed
And you
jury
presented
instructions.
evidence on them?
They were. If you look at the defense issues in the pretrial statement, it's broken down. The issues that we identified in the joint pretrial statement is that we had to prove by the greater weight of the evidence these coverage exclusions, that the roof was damaged, it was in a damaged condition, and had to be replaced prior to the July 2012 storm. And that's how the issue was taken from us and not fairly presented to the jury because it was not.
One of your defenses, too, was that there was no hailstorm, or if there was, the hail was so small it couldn't harm the roof, correct?
Not precisely, Your Honor. There was no dispute that there was a hailstorm. We never disputed that there was a hailstorm.
Size of the hail?
Tiny hail, friendly hail.
The question is, and this was essentially a battle over competing roofing experts, the question was, what was the amount of damage caused by the hailstorm? Our expert testified that it was minimal to non-existent. Our experts testified, and there were admissions, that this roof was in a damaged condition prior to the July 2012 storm. That was the position that we had argued to the jury, but it wasn't something
Your
that...
experts almost took the position that because it was such an old roof, it was more bulletproof to hail than the across the street neighbors, right?
This roof, yes, Your Honor, and this roof had leaks prior to the July 2009 purchase by Mr. Bush in a foreclosure sale. It had a leak in July of 2012, 1 month prior to the storm, which allowed the inspector to go out, and the inspector testified at trial.
This wasn't a leak case for the hail damage, was it?
This was not, no, it was not a leak case, but the fact that the roof had a history of leaking was one of the aspects, it was one of the elements of our argument and proof that this roof was in a damaged condition prior to July of 2012. And again, we had a fair opportunity to argue that at trial. Our point is that there was a directed verdict, and the issue of our affirmative defenses and coverage exclusions was taken from the jury. They did not have a fair opportunity to sit in the jury room with the instructions and with a verdict form that allowed them to essentially find in our favor, because those affirmative defenses had been stricken from both. We have a second issue, Your Honor, and that's the improper instruction on legal causation. SIBO has clarified that to a large extent. Certainly the CCD instruction, it's what is appropriate in these circumstances. But given that causation is the core issue in this case, that it's fundamental, the issue still remains that the trial court gave not only a CCD instruction, it gave an EPC instruction. So
Did you have an instruction proposed on that issue yourself?
we did. We had proposed the EPC instruction, a single instruction. They had proposed a CCD instruction. They're correct about that, but the end result is the trial court gave both. And SIBO clarifies that these are mutually exclusive causation theories. So the end result was the plaintiff got 2 bites at the causation apple. There's an EPC and a CCD instruction
Well, based
in
on
succession.
SIBO, what instruction should have been given?
Based on SIBO, it should be the CCD.
And that's the one they requested.
It is the one they requested, yes, Your Honor.
That's the one you objected to.
It is, Your Honor.
Well,
Did
no,
you-
actually, but the other instruction was proposed by, well, you all.
By us, yes, Your Honor, the EPC
So you're
instruction.
saying that it was error for the trial judge to do what you requested, and we should reverse on that?
No, Your Honor, it's error
You
to,
said it's error to give both,
it's error to give both.
but you're the ones who requested the second one.
We requested one, Your Honor, it's the EPC instruction. They requested the CCD instruction.
But you didn't have it.
And the error is that both were given. These are
Did
mutually
you
exclusive
request to
instructions.
withdraw the EPC?
We did not, Your Honor, and we didn't withdraw the one that we were in favor of. But again, this is a,
Given the plaintiff's instruction and gave yours only, we'd be in trouble, wouldn't we?
that'd be probably an argument on cross appeal if that had happened. And the same error would still obtain that 2 instructions were given, plaintiff was given 2 bites at the causation apple.
But if the plaintiff had gotten their way, it would have been only one instruction, and that would have been the proper instruction.
It would have been, yes, Your Honor. And here, two bites at the apple were given. Our third basis for the appeal are the evidentiary issues. There were 3. First, Ms. Montañez lives across the street. She was able to testify not only that she observed the hailstorm, but also that the hailstorm damaged her roof. That's problematic in that she's not a roofing expert. She has never even been on her roof or really any other roof.
Y'all raised a 403 argument to that it was the prejudice outweighed the probative value.
It is, Your Honor.
You're not
And-
claiming there wasn't some probative value to the fact that a house across the street had hail damage sufficient, whether it was your insurance company or another one, or whether it was a voluntary roof replacement. That is relevant as to whether there was sufficient hail damage to roofs in that neighborhood to require replacement, wasn't it?
Potentially, Your Honor. But the key to our argument is the next thing that she testified to, which is not only that my carrier came in and gave me the replacement value for my roof after the July 2012 storm, a roof she never replaced, but that she identified HCI as the carrier that did so. And we don't think there's any probative value to identifying a party sitting in the courtroom as the party that repaired her roof.
But
Other than to suggest-
in closing argument, remarkably, it was plaintiff's counsel who clarified what use the jury should make of that evidence, wasn't it? It's like, I'm not bringing them in because they paid hers and didn't pay ours, but that's a breach. You should look at this because hail damage here, hail damage across the street, replace the roof, replace the roof. I mean, and twice plaintiff's counsel made that clarification to the jury, essentially.
But, Your Honor, I mean, the damage has already been done at that point. We think that the probative value of that is 0. It should not have been testified to in the first instance.
Well,
That
the
was highly
size of
prejudicial.
the hail was at issue, right?
Well, indirectly, Your Honor. I think the issue was walking on Mr. Bush's roof. What was the damage done to that particular roof, and hail damage is going to affect
Yeah, but
even
didn't your
houses.
experts say that based on, the observation of the roof, that the hailstones were small, were smaller than what the
I think that was
plaintiff's
his,
expert was contending?
I think that was his inference based on the minimal to non-existent amount of hail damage that he saw on Mr. Bush's roof.
Right.
And all roofs are not the same.
But that was in part based on the size of the hail. The suggestion was the hail that hit the plaintiff's roof here was small, too small to do the damage they were claiming.
Or that there were other conditions that would, irrespective of the size, that would not have caused damage
But
to
size
Mr.
was a
Bush's roof.
factual issue.
It's a factual issue, Your Honor, I guess, but it is not a key one in that we did not dispute the fact that there was a hailstorm. There was some testimony on their part about the size of the hail, but again,
But
we
your
think the more
denial,
relevant
the
evidence-
denial letter, as I understand from the record, was based in part on a weather report, CompuWeather, and I may have it wrong, that said it was 3/4 of an inch. Plaintiff brings in Glenn Richards, and you have fact witnesses saying golf ball size. You have Glenn Richards, a meteorologist, saying big hail. So, I mean, that was a disputed issue.
It is, Your Honor, but again, the more relevant determination is that was this roof damaged prior to the July 2012 storm? And because this roof had a history of leaks, because you had an inspector out there even 1 month prior to the storm inspecting it and seeing all of the visible signs of age, such as curled shingles,
And the jury heard all that.
the jury heard all of it, Your Honor, and that gets back to our key issue. It's a tough burden for us to prove. We have to show the greater weight of the evidence that all of those conditions was the proximate cause, but we weren't able to fairly present that to the jury because those affirmative defenses were stricken from the jury instructions and from the verdict.
We've got about 4 minutes left for rebuttal. I don't know if you want to
Your Honor,
say
I'd like to
that.
reserve the balance for rebuttal and to respond to the cross appeal. Thank you.
Good morning. Mark Nation on behalf of the Bushes. I think I've heard a new theory. I'm going to call it the invited tipsy coachman on the concurrent cause. I don't see any error there, and I can address it if the court has any questions on it.
I don't think you need to address that particular issue.
Okay, I didn't think so. I do want to correct some factual statements that have been made here and in the record, or in their briefs. In the initial brief, counsel said HCI, and this is with regard to the affirmative defenses, HCI included these defenses in its proposed jury instructions. They never submitted any proposed jury instructions before the trial or after the trial, or during the trial. They then cite to a page, trial transcript 668, which is the middle of somebody's testimony. And to be cautious, I then went to the record 668. And that's a part of the insurance policy, the certification that it's the policy. They never submitted any jury instructions or a verdict form, in this case, anywhere. In their reply brief, they say, we contend that they waived any argument with regard to the verdict form because they agreed to it, and they dispute that they agreed to it. That's wrong. I proposed a verdict form at trial based on the evidence that had been adduced. I gave that to Mr. Swift, and on page 760, we agreed to the verdict form, page 760 of the trial transcript. The verdict form was agreed to. I agree with counsel that typically on an all-risk policy, we have the burden of proof to show damage during the policy period. Usually you give the bookends of the dates. Then the burden would shift and then they prove exclusions. This case was being tried at the same time the Newell case was being decided here on whether that was the right way to proceed in all-risk policy cases. That was my case. I believe Judge Evander, you were on that panel, I believe. But it hadn't been decided yet. And the case goes in pretty well. And so I propose a verdict form where we have all of the burdens of proof. And Mr. Swift at trial agreed to the verdict form. And the verdict form required that I prove that damage occurred on the day of the storm. and the verdict form then required that I prove the monetary amount of damages that were due to the storm. So all the burden of proof's on me. They stipulated, they agreed that that was the verdict form. After we got that, so I go, you were agreed, right? That's the verdict form. Yes. I then said, I got a motion for directed verdict. And really, the motion is directed to a very small issue, and that is, these are not affirmative defenses. Affirmative defenses are yes, but yes, I may have crashed into you in my car, but I have a release. What they have here are defenses, and they were free to argue those defenses and did. But the next misstatement that was made here today and in their briefs is that HCI requested that these affirmative defenses be included in the jury instructions. That is not true. That did not happen. They never proposed any jury instructions. And in fact, this is the charge conference, page 744 to 759. They didn't object to one jury instruction that I proposed, except the concurrent cause one. And we know now they were wrong about that. Nor were they denied any jury instruction that they requested. And it's right there in the charge conference. And based on the verdict form, I can't understand how they would say, well, we needed to have some burden here when I carried the entire burden in the case. And so what they cite, they say here that in their brief, the issue, the affirmative defenses being in the jury instructions, were argued at length. That is not true. And they cite page 770 to 774. 770 to 774 was my DV argument. And the only argument I made in those 4 pages was, these are not affirmative defenses. They're free to argue them. And they're saying that, well, then they requested them in the jury instructions. They did not. They requested them in the verdict form. They did not. And so the narrow issue, which apparently is their main issue now, was my motion for directed verdict. And the only thing that dealt with was, these are not affirmative defenses. These are just defenses. And they did argue them. They didn't ask for them in the verdict form or in the jury instructions. So I'll move on from that issue. Ms. Montanez's house is 110 feet away. Nobody disputes that. Built at the same time, same builder, shingles were the same age. Both homeowners were home during the storm, both insured by HCI. The claim was reported in July of 2012 for both homes. HCI goes out to Ms. Montanez's house and says, you have hail damage on your roof from this storm. They go out to my client's house and says, the hail was too small to cause damage. And so, being aware of the issue in opening and in closing, I bring that to the jury's attention and I make it clear. I'm not bringing this to your attention to say, they paid this one and didn't pay ours, so that's a breach of contract. The only reason that's relevant to you as our jury is because they are saying that the hail is too small on the Bush side of the street, and they're saying it was big enough on the Montanez side of the street. In the denial letter, that is specifically what they said, that the hail was too small to cause damage. Let me see if I have anything else on that. I don't think so, though. No, I don't. And the other issues weren't addressed. I don't find, if you have questions about them, I'm happy to address those. Okay, cross appeal, small issue, but the claim was brought for the roof and for the pool enclosure. They have an affidavit from an adjuster who did not come up with the value of the loss, who says, I've looked through the records. And apparently they sent a field adjuster out, and this is what his affidavit says. The field adjuster, who's unidentified in this affidavit, at the motion for summary judgment. The field adjuster determined that the replacement cost is $1,501 for the screen. And that's all it says in the affidavit. Doesn't say how the field adjuster inspected it, how he came up with the amount, when he came up with the amount in relation to when he recorded it, how that document then got to the insurance company, nothing. It's hearsay within hearsay. If they're going to rely on 1501 as being the number for RCV, they should have had the field adjuster write the affidavit. But it still wouldn't have helped them, because we had a competing affidavit that said, no, the RCV is basically $2,500 for the full screen. And this is not a case where the payment from the insurance company says, hey, if it costs more, let us know and we'll review that as a supplement. In their letter to my client, which is in the record, that payment for the pool screen that is short says, we've concluded our investigation and here's a check for your total loss amount. And they then call that letter, they refer to that letter themselves as a declination of coverage. And that should have just been let to go to the jury for, because there was competing evidence.
What does the policy, though, speak about there? The issues as framed almost seem like the policy says insurance company will essentially make you an offer, as you say, the 1501. If you don't think that's enough, go out and actually get it repaired, and then if it costs more, we'll give you more. Is that?
That is kind of right. That's kind of how it works. What they say is, we'll come up with the replacement cost, but we'll only pay you the ACV, the actual cost, until you make the repairs. Okay. What we said, and what our affidavit said is, your replacement cost is a low ball, and your ACV is a low ball. And so we have a complete dispute as to the amount of the loss. This isn't a case where they paid the ACV and we want the RCV. Our numbers are completely different than theirs. Does that answer that? Okay. Let me see if I have anything else on that. The 15-year-old roof, and I'll just make this point, I think Judge Edwards, you raised this. This policy was issued, I think the house was 11 years old. And the insurance company issues a policy and said, on our solemn oath, if you have direct physical loss, we'll pay for a new roof, replace your roof. And the roof was 11 years old. When the roof became 12 years old, they renewed it and said, on our solemn oath, we will pay you for a new roof if it gets damaged. They renewed it again when it's 13 years old, 14 years old, 15 years old. They file a renewal policy saying, we'll replace it if there's direct physical loss. First thing that happened, they go, roof's too old. So I think that addresses that. All right, thank you very much.
Thank you.
Let me begin by clarifying the record with respect to the motion for directed verdict on our affirmative defenses. The joint pretrial statement that begins at page 785 of the record breaks out our coverage exclusions as affirmative defenses. The plaintiff's proposed jury instructions at 1782 of the record, with which we agreed on this point, breaks out our coverage exclusions as affirmative defenses. The plaintiff's proposed verdict form at 1827 of the record, with which we agreed, breaks out our affirmative defenses based on the coverage exclusions.
And was the verdict form changed?
And it was changed, and the jury instructions were changed, Your Honor, and this occurred after the directed verdict on our affirmative defenses. So to say that we agreed with the jury instructions on the affirmative defenses doesn't take into account the fact that we had already been ruled against. So I would like to bring that clarity with respect to the record. And again, that's our key issue on appeal, that in case after case, the burden shifting is very clearly set forth, and we would have liked the benefit of having a jury instruction and verdict interrogatories on that
Let me
verdict
ask you a
form.
question on the cross appeal. Given the granting of the summary judgment, that partial summary judgment on that issue, is it your position that matter is resolved, or is it your position that they could still make a supplemental claim upon doing, upon doing further repairs or getting it replaced?
Your Honor, I haven't thought about it in the context of this case. I can note this court's Slayton decision, which we think is on point, where this court observed that the insureds were still free to bring a supplemental claim. And with respect to the motion for summary judgment and the cross appeal, you had three components of damage. You had the shingle roof, you had a metal roof, and you had the pool enclosure. In each case, we calculated the actual and the replacement value. With respect to the pool enclosure, we paid the higher replacement value. They submitted a supplemental claim with respect to the metal roof. Now, they could have submitted a supplemental claim with respect to the pool enclosure, but they didn't. Instead, they filed a complaint. And the only evidence that they put in the record to essentially show a dispute of fact on with respect to the pool enclosure is a 5-paragraph affidavit prepared 27 months after the filing of the complaint. So how could we have breached the contract when we paid that amount, when the policy indicates that a further amount may be paid once you have the repairs made, and we never received an invoice or proof of repair? How can it be a breach of contract? So, Your Honor, again, I haven't thought about it in respect to this case, but certainly this court's decisional authority indicates that in a very similar policy, the insurance can submit a supplemental claim. If there are no further questions, I thank the court for its time this morning.
All right, thanks. We're going to take a short 10-minute recess and adjourn to the coffee room. Oh, you, okay, go right ahead. Go right ahead, we'll take the cross appeal, rebuttal.
The only issue that raised Slayton, in that case, the insurance company said, here's our payment. If it costs more, let us know, and we'll review that as a supplemental payment. That didn't happen in this case. They sent out a letter that says, we've concluded our investigation. This is the total loss amount. And then they refer to in the last paragraph, they call that letter their declination of coverage. Completely different situation from Slayton. And to the extent he's arguing we had to go get an estimate before filing suit, this court and every other DCA has dealt with this in the sinkhole context, where their arguments had been, you have to have a contrary report to show us that we're wrong before we can breach a contract. Supreme Court and every DCA that's dealt with it says we don't have to give them a contrary report to, in the language of the 5th DCA in Peachtree, see if they were only kidding. Thank you.
Thank you. Now we'll take our recess.